Former high school cheerleader Brooke Skylar Richardson is in court, charged with aggravated murder, child endangerment, involuntary manslaughter, and abuse of a corpse. Today, both the prosecution and the defense present their closing arguments. Today, Brooke Skylar Richardson's fate lies in the hands of the jury. The question remains, was justice served in this case? Today, we find out together. This is the finale of BETHEA'S BYTE Reloaded Throwback, Ohio versus Richardson. And it begins right now. Welcome to Judgment Day. Welcome to the final installment of BETHEA'S BYTE Reloaded Throwback, Ohio versus Richardson. I'm Ernest Bethea, the last outlaw, and yes, I said correctly. This is Judgment Day for Brooke Skylar Richardson. Today, after these closing arguments, her fate lies in the hands of a jury. Today's the day we find out together the answer to the question that I started with at the very beginning. Was justice served? Before we get started with the closing arguments, I want to thank everybody for joining me. I want you to be sure to like, share, subscribe, and comment to support the channel. Smash that like button is a free way to help out the channel, so I appreciate that as well. If you want to jump on the open panel, the panel is always open. Click on the link below. Click on or copy the link. Put it in a new browser tab or window. Come join me. We'll talk about the closing arguments and the case in general. To everybody in the chat, all your comments, statements, and views, it's all speculation, deduction, theory, and opinion. It's not considered evidence or fact. Your opinions are welcome here. That's what this channel ran on. Your opinions are welcome, but attacks on other channels are not. If you don't like an opinion, all you gotta do is click the three dots to the right side of their name, click block, and you'll never have to hear from them again throughout. I will boot you for anything racist, homophobic, any kind of spamming, politics, or religion. I will quickly boot you that quick. All right, here's the copyright disclaimer. This might be the last time. These might be the last times I do this for at least in this for this case. Your trigger warning, I want to protect your mental health. So, if you see and hear anything throughout the closing arguments all leading to the verdict that you cannot stick with as far as your mental health is concerned, turn away from here. As the last line as it tells you, that viewer discretion is strongly advised. All the closing arguments, the verdict, and everything you will see here is coming courtesy of my good friends at Court TV, your front row seat to justice. All right. Without any further ado, it's now time for closing arguments in the state of Ohio versus Brooke Skylar Richardson. Let's get it.
This is the case of the state of Ohio versus Brooke Skylar Richardson, case number 2017 CR 33292. We are here today in continuation of our jury trial. Mr. Knippen, anything preliminary to come to my attention before we get started? Mr. Rickers, anything preliminary to come to my attention before we get started?
Your Honor, we would just like to renew the Rule 29 motion for the record.
All right. Any argument? Anything from the state?
So, Your Honor.
All right. The Rule 29 motion will be overruled. Ready for the jury?
Yes.
All right. Mr. Mullins, go get our jury. Ladies and gentlemen, welcome back. Was everybody able to follow my instructions and admonitions last night and into this morning? Yes, sir. All right, we are now going to hear the closing arguments of the attorneys. As I have told you before, what the attorneys say in the case is not evidence. These closing arguments are the opportunity that each of the lawyers have to argue to you what they believe the facts have shown, and to argue for a specific verdict and to go over the law with you. If you find a disagreement between what they say as to the facts and what you believe, again, what they say is not evidence because the evidence is closed in the case. We have agreed in advance that we will, each side will get 1 hour for their closings. Because the state of Ohio has the burden of proof in the case, the prosecution will address you both first and last with the defense in the middle. Ms. Kraft, you may proceed.
Unwanted. That's what Brooke Richardson's daughter was. Unwanted. To outside observers, Brooke Richardson had the perfect life. She grew up in a small town. She was a cheerleader for the high school football team. She obsessed over her appearance. She was in love with her new boyfriend, and she was planning for college in the fall. She was determined to maintain that perfect life at all costs. Having a child that was the result of a less than 1 month casual relationship was not part of her perfect life. So Brooke kept her secret, a secret that she knew had the ability to destroy her perfect life and all of the plans that she had made. A secret that would forever alter her relationships with the two people that mattered most to her, her mom and Brandon. Brooke's secret was that she was pregnant by a boy that she wanted nothing to do with, and that she was about to give birth to his child. So when it came time to come clean and tell everyone and to start making plans for the birth of her daughter, or to continue to hide and conceal, she chose the latter. On May 7th, 2017, when Brooke delivered her daughter in the middle of the night, alone, at her home, with her parents and her brother asleep in the same house, she made the choice to kill her newborn baby and bury her lifeless body in a shallow grave in the backyard. She then cleaned up the mess, erased any trace of evidence that her daughter ever existed, so that no one would ever know and her secret would remain safe. Brooke chose her own perfect life, ladies and gentlemen, over that of her daughter's. Let's review the evidence. Over the course of the past week and a half, we have learned that in August of 2016, Brooke hung out for a short month with Trey. They had sex 2 times, once unprotected, once protected. Towards the end of that month, Brooke broke off all communications with him. The relationship was over. In January of 2017, Brooke started dating Brandon. He was a year younger than her. Everything was going great with them, and they quickly fell for one another. Things were going good for Brooke. She had a great relationship with Brandon, and she had plans to attend college in the fall. April of 2017, Brooke becomes fearful that she may be pregnant. She asks her mom, schedule an appointment for me with the OBGYN for the purpose of obtaining birth control. But secretly, she wanted to find out whether or not the pregnancy she suspected was a part of her new reality. Was she actually pregnant? April 26th, 2017, Brooke's worst fears were realized when Dr. Andrew confirmed the pregnancy. He told her that she was in the 3rd trimester and that she would soon be giving birth. Brooke's response to Dr. Andrew was to burst into tears and tell him, "I cannot have this baby and nobody can know." Dr. Andrew told her, "You have to come back. You have to have an ultrasound. We have got to get prenatal care started for your daughter." Brooke, however, never followed up with that doctor appointment. She never told anyone she was pregnant. She tried to conceal her pregnancy from everyone. She took absolutely no efforts to bring her daughter into this world. The only thing she did, from her own statement, we know, she researched ways on the internet of how to get rid of a baby. In the early morning hours of May 7th, 2017, Brooke Richardson gave birth to her daughter alone in her bedroom. She didn't call for help. She didn't yell out for her parents or her brother. She didn't call 911. She didn't scoop up her daughter and rush her to the hospital herself. Rather, she took her daughter's life and she disposed of her remains in the backyard. And then she disposed of all other evidence in a still undisclosed location. 2 months later, Brooke's perfect crime begins to unravel. July 12th, she returns to Hilltop OBGYN, but this time she sees a different doctor. However, what Brooke doesn't know is that Dr. Andrew has already told Dr. Boyce about the prior appointment. And so Dr. Boyce confronts Brooke. Where is your baby? What happened to the pregnancy? She burst into tears. She says, "I had her, I buried her in the backyard," and she claims she was stillborn. You are now aware that as a result of that disclosure, the sheriff's office was contacted. They started an investigation, and as a result of their investigation, Brooke's daughter, her skeletal remains, all that was left of her, was found in the backyard in the tree line of the Richardson home. Ladies and gentlemen, when we first started this case, during the very first opening statement during voir dire, we talked to you about whether or not you could make determinations of life from the defendant's own statements and from her actions both before and after her daughter's birth. Circumstantial evidence. It's evidence that carries the exact same weight as direct evidence. The defendant's emotional reaction to confirmation of her pregnancy was so extreme that it required suicide warnings. If you are going to do anything to yourself or to your child, you have got to tell someone. No plans ever made for the birth of her daughter. No prenatal care, no diapers, no blankets, no prospective adoptive parents, nothing. Labor for almost 36 hours. Her daughter's birth is now imminent and still nothing. She chooses to remain silent. Her daughter is born into this world, still nothing. She doesn't ask for help. She doesn't seek emergency assistance, medical assistance. She doesn't get her daughter to the hospital, nothing. Rather, she buries her in the backyard and disposes of her remains and all evidence of her daughter's birth. Her reaction to her daughter's death, to her mom, OMG. To Brandon, I'm happy. And then off to the gym she goes to further erase any evidence of her daughter's existence. Her perfect life was back, and there was no chance of her secret ever destroying it. She provides alternate explanations for everything she thinks the evidence is going to show. She joins a truth, how the baby died, with a fiction, an accident. I think I might have killed her when I squeezed her. Suffocation. She was born in the toilet. Drowning. And one other very important thing. In the very first interview, without any prompting whatsoever, Brooke Richardson says to the detectives, "Am I going to be in trouble for murdering her?" Ladies and gentlemen, you are able to consider all of the circumstantial evidence, and it carries the exact same weight. As a result of the defendant's actions, Brooke has been charged with multiple offenses. Let's go through them. Aggravated murder.
8-minute mark. I apologize for that.
Brooke Skylar Richardson purposely caused the death of her infant daughter. Purposely. A person acts purposely when it is their specific intention to cause a certain result. If based on the evidence that has been presented to you and that we have discussed, you believe that within the first 24 hours of her life, the defendant purposely caused her daughter's death by suffocation, strangulation, drowning, or any other means, that is aggravated murder. Endangering children. Brooke Skylar Richardson, who is the parent of a child under 18, did recklessly create substantial risk of health or safety to her infant daughter by violating a duty of care, protection, or support which resulted in her daughter's death. The definition of recklessly: a person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that his or her conduct is likely to cause a certain result or be of a certain nature. A person is reckless with respect to his circumstances when, with heedless indifference to the consequences, the person disregards a substantial risk that such circumstances are likely to exist. Again, based on the evidence, ladies and gentlemen, if you believe that the defendant took no action on behalf of her daughter, she sought no medical attention, she didn't call 911, she didn't summons assistance, and that violation of the duty of care that she owed to her daughter resulted in serious physical harm, that is endangering children. Involuntary manslaughter. Brooke Skylar Richardson did cause the death of her infant daughter as a proximate result of committing felony endangering. If you find that she's guilty of the offense of endangering children, then you have also found her guilty of this offense. The serious physical harm is the death of baby Richardson, an abuse of a corpse. The defendant, not being authorized by law, did treat a human corpse in a way that would outrage reasonable community sensibilities. Again, based on the evidence, if you believe that she disposed of her daughter in her backyard, you have found abuse of a corpse. And remember, ladies and gentlemen, beyond a reasonable doubt, it's based upon your reason, it's based upon your common sense. The state submits to you that it is clear from all of the defendant's statements and actions in this case that the defendant never had any intention of having her daughter. As Mr. Knippen told you in the second opening, the decision on Brooke's daughter's life was made before her child was ever born. She was never going to see the light of day. On May 7th, 2017, Brooke Richardson purposely killed her daughter, destroyed all evidence of her existence, and went on with her perfect life as if nothing had ever happened. That was her perfect life, ladies and gentlemen. And baby Richardson never fit into that equation. You have now had an opportunity to hear all of the evidence. Employ your reason and your common sense, draw logical conclusions from the evidence, and find Brooke Richardson guilty for the death of her daughter. Thank you.
More than 2 years ago, they found out, they knew, that this cremation story was false. They knew it. They knew that the burning and charring of the bones that Dr. Murray had opined were true were false. They knew it. And yet they came in here more than 2 years after they know that's false. And they continued throughout the trial to tell us all, well, Skylar said it. Skylar said it. Even though their own doctor, Dr. Brown, admitted that it's silly, it is impossible to light a baby or any human being on fire with a lighter. Why'd they do it? Why would they come in here and tell all of us that this cremation and fire should be trusted? Why'd they do it? If they knew, they know. They know it's not possible. We all know. Our common sense tells us it's not possible. Science tells us it's not possible. Because they know that if you have reason to doubt what Skylar said about cremation and burning, then you have reason to doubt the other things she said that the detectives told her to say about signs of life. Well, if you really loved her, we know you saw signs of life. They know it. They know it's false. They know it offends our common sense. Yet they came in here for 2 weeks and they said Skylar cremated her baby. They continued that narrative. Their story, even though they know it's false. And it's sad. What are the chances, as they would have us believe, what are the chances that this doctor gets it all wrong, it later admits she's wrong, but it actually is helpful because, well, Skylar said it. We'll just keep going along that narrative. What are the odds? Well, we know in this case the odds are actually 0 that you can light a baby or a human being on fire with a lighter. It is impossible. And you'll see in the interrogation tapes, they talk to Skylar about how'd you put out the fire. She's confused. I think you'll see that. Shoot to the flames. I had to throw dirt on the flames. They hid the state fire marshal's report from us. They hid it from us. You heard Lieutenant Fain testify on the stand. He saw it. They don't even put their lead detective on the stand in a homicide case. Never heard of it. Ever. The state fire marshal report tests 3 things. The gravesite, no accelerant used, no ignitable fluid used. They don't show it to us. And then they don't want us to display it to you. Why? Because they know. If you have reason to doubt the burning, you have reason to doubt the signs of life. After they broke...
I apologize for interrupting. Ladies and gentlemen, the fire marshal's report is not evidence in this case, and whatever evidence may have been in that report is not for your consideration. You are to disregard the part of the closing argument that refers to that as fact or the inference that it was hidden from the defense. Mr. Rickers, you may continue.
You heard people testify to it. Lieutenant Fain testified to it. Before I forget, I cannot stand back up. And so just because I don't stand up after Mr. Knippen stands up does not mean that I don't have something to say. The government has the burden of proof, so in closing argument, they get to go first and last. So I don't want you all to think that I don't have something to say. That's not why I'm not standing back up. With jury service comes significant power. And I can tell that you all take your jobs very, very seriously. And you will soon have the power to start the healing process or to destroy. Annabelle has still not been returned to the Richardson family. And your verdict in here today will last forever. It is extremely, extremely rare that a verdict is ever overturned at any point. It will be final.
Objection.
Sustained. Jury will treat their verdict as if it is going to be final.
Pretty soon you'll have 3 jobs to do. The first job will be to listen to the law that the judge gives you. And he'll give you jury instructions. And that's the law in the case, what the judge gives you. Nothing else. We all come in here with different thoughts about the law, what it should be. But the law you all swore an oath to follow will be what the judge gives you. And he'll give you those instructions, and you can read along with them as he reads them aloud to all of us, and you can actually take them back into the deliberation room with you. The second job you'll have to do is to explain to each other why you think the facts of the case are what they are, and applying those to the law in the deliberation room. And then third, you'll be asked to render a lawful verdict that follows the law that the judge gives you. So for the next few minutes, I want to talk about some of the jury instructions that you will get, some that you have not heard from the prosecution. Can we toggle the HDMI, please? Thank you. Now the first, I know that's hard probably to see. You'll have this. First instruction, and we've heard a lot about it, is burden of proof. The defendant is presumed innocent until guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged. And it's their burden. It's the prosecutor's burden. My fear sometimes with burden is that every day in our life, if we have two parties that are in dispute, that we typically in our everyday life, we say, well, who's more right? Is party A more right than party B, or is party B more right than party A? But in the law, criminal law, remember when we talked in Carlisle about Lady Justice and she was blindfolded with the scales? If money is at stake, that is the case. It's just ever so slightly tilted. It's called preponderance, more likely than not. When the government comes into our homes to try to take our children away, it's clear and convincing evidence. Those scales must be tipped much further. But the highest burden in the land, before you strip someone of their liberty in a criminal case, it is beyond a reasonable doubt. It is the highest. Next slide, please. Reasonable doubt. Reasonable doubt is present when you, after having carefully considered and compared all the evidence, cannot say you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything related to human affairs, or depending on moral evidence, is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, a very critical instruction in this case, and that you didn't hear when you heard about the child endangering and a lack of treatment that the prosecutor just told you, is an instruction regarding proof beyond a reasonable doubt, meaning you would need proof, you would have to not have any doubt of a live birth. Objection.
Overruled.
Next slide, please. This is the instruction that you will get, and it will be in the natural consequences paragraph. With respect to the charges of aggravated murder, involuntary manslaughter, and child endangering, the defendant cannot be found guilty of any criminal behavior with respect to her unborn child while she is pregnant. As I told you, and this is the judge, as I told you in my initial voir dire, the most frequent example of this, which is not an allegation in this case, is where an expectant mother takes illegal drugs and the child is born addicted to those drugs or dies as a result of that drug usage. The mother in that example cannot be prosecuted for endangering or killing her unborn child. Likewise, it is not a crime for the defendant not to obtain prenatal care or for her to do things while pregnant that may be harmful or injure her unborn child. In order to find the defendant guilty of aggravated murder, involuntary manslaughter, and/or child endangering, the state of Ohio must prove beyond a reasonable doubt that the child alleged to be the victim, in this case, was born alive. and you'll get these instructions. I created, because this is not typically how we think, and this case has gone in an odd fashion. The prosecutor has attempted to poke holes in the defense. Usually it's the opposite. Usually the prosecutor has science and the defense tries to debunk the science. This case, it's been almost the opposite. The prosecutor's like, well, we're poking some holes in the defense. So I created, next slide please. And Your Honor, the slide that's on there is the same as these. Can everyone see this? So this goes with that instruction that I just read to you aloud about a live bird. And it goes to the burden beyond any reasonable doubt. So if you believe that we've proven there's a stillbirth, it's obviously a not guilty verdict. If you think it is highly unlikely there was a live bird, not guilty. Less than likely there was a live bird, not guilty. There probably was not a live bird, not guilty. I think it is unlikely there was a live bird, not guilty. I do not know if there was a live bird, not guilty. Maybe a live bird, not guilty. I think possibly a live bird, not guilty. I think probably a live bird. That's not guilty. Live birth is likely, not guilty. Live birth is highly likely, not guilty. The clear and convincing evidence isn't even as high as reasonable doubt. Clear and convincing live birth is a not guilty verdict. And by the way, I believe Skylar had a stillbirth. But what I have got to do, my job, is to explain the burden of proof. As the judge talked to us in voir dire about 100 people, and if 99 are guilty and 1 is innocent, our law, people have fought for this. Our soldiers have fought to keep us a free country for our Fifth Amendment rights. Our law would prefer to let all 100 go than to entrap an innocent. That's why we have this high burden of proof in criminal cases. But it's not the way we normally think in everyday life. Another way to think about the burden of proof and reasonable doubt is, imagine with me you have a box, okay? And you put this box somewhere that you know it cannot be tampered with or opened, and you put a cat and a mouse in a box, okay? You leave for 10 minutes, and you come back. And you know no one's tampered with the box. You open up the box, and the cat's in there, and the mouse is gone. Beyond a reasonable doubt, the cat ate the mouse. The mice just don't disappear out of thin air. But let's assume the same set of facts, and you walk away for 10 minutes. And you come back, and there's a hole in the box. Maybe the mouse ate a hole in the box and walked out. Maybe the cat ate a hole in the box and the mouse walked out. Maybe the cat ate the mouse. But you have reason to doubt. You have reasonable doubt as to whether or not the cat ate the mouse. The important part of this is that one hole, one reason to doubt is a not guilty verdict on those top 3 counts as it relates to live birth. And that's the law, and you'll have it in your hand. You can each have different reasons to doubt. Your reason to doubt can be different than his reason to doubt. You can have more than one, but if you have one, you have reasonable doubt as to a live birth. And I put together some of my thoughts, and again, you can disagree with these, you can have your own. Slide, please. Intrauterine growth restriction. We've heard a lot about it. And the prosecutor fought really hard on the 32 centimeter fundal height measurement that Dr. Andrews said he's taken thousands of fundal height measurements, and every time he uses a measuring tape. But they fought hard. They said, they fought hard for a reason. Fought hard for a reason. The doctor, you'll see on page, it's either 25 or 35 of the Hilltop records, you'll have them. He took 2 measurements that day. One was a fundal height measurement that he took with his hands, meaning with a measuring tape. And the other he did, and it says US transabdominal. It's a transabdominal ultrasound. He took that, which is subjective, by the way. It's not that accurate. But he took that by taking an image, an ultrasonic image, of Skylar's belly and Annabelle. And he also estimated in that Skylar was 32 weeks. But he also did the measurement, 32 centimeters, which we've heard. Every doctor agreed that when you do a fundal height measurement and when you write something down to a precise centimeter, you do it with a measuring tape. But they fought it and they fought it and they fought it. If I told you I made this podium by hand, made by hand, and the prosecutor thought it would hurt their case, they'd stand up here and say, you didn't use a saw. You didn't use a saw. You said you did it by hand. It defies our common sense and logic. But they fight us on it because they know it gives us reason to doubt. Growth restriction. We can look. I mean, some of these witnesses that came in, they have no motivation to lie. These teachers and counselors, they had no idea Skylar was pregnant, let alone 9 months pregnant. We can see that with our own eyes. She was growth restricted. Next slide, please. White. Skylar has I think we can all agree that prior to May 7th, Skylar had never seen a dead baby. And she's asked, what color? She doesn't say purple or bluish or pink, as babies are. She says white, I think. White. Never cut the umbilical cord. Very clear throughout both interviews. Never had to cut the cord. Skylar, medical significance of that, Skylar has no clue. The detective has to tell her what the placenta is in the second interrogation. She has no clue that the umbilical cord carries oxygenated blood from the placenta to the fetus. That a cord either snapping at delivery or in utero is essentially a stillbirth. I mean, that's what happens. When babies don't get that oxygen-rich blood from the placenta, they turn white because they don't have the oxygen and they die. Skylar had no idea what she was saying. In fact, at one point, she thinks she could have hurt Annabelle by not cutting the cord. Next slide, please. Placental abruption. Bleeding in the 3rd trimester. Next slide. Skylar goes back to the same OBGYN where her aunt works. Her own aunt works at Hilltop. She knows they know she's pregnant. Her aunt's there. Goes back to the same OBGYN. Skylar's life history. You all heard from people. They're not liars. I don't think anyone thought that they were. A zebra does not change its stripes overnight, as the state would have you believe. No evidence of live birth. Their own doctor, Dr. Latham, who they brought in from out of state. No signs of trauma, no signs of burning. That in and of itself is reasonable doubt. Next slide, please. Skylar's repeated statements in 2 interrogations, they want you to ignore them. Describing a dead baby. Never using the word stillbirth or stillborn, but describing a dead baby. Body just came out of her. She was dead. Not breathing. Not moving. 17 times denying the fire. a burial with marker and flowers, a flower pot and flowers, and naming her child. They keep talking about concealing and destroying, attempting to lower their burden because the natural decomposition process occurred after you bury someone. Of course. Women who kill their children, we've read about it, we've heard about it, throw them in dumpsters. They try to distance themselves from the body. Throw them away in trash cans, like towels. Skylar named her child. She put her in a gravesite that she could see from her bedroom window and kept her close, put flowers on her grave and marked the grave. And they continue to talk about concealing and destroying. And the tampering with evidence charge is gone. Yet they continue to do it. Next slide, please. This is the not guilty instruction. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. Thank you. And that instruction goes with live birth, burden of proof for the top 3 charges. The top 3, and they know it. And that's why they keep doubling down with all of us on the fire. Now, we heard in Vordaer, I think when Ms. Kraft was standing up and speaking with us, she said this isn't a science case. Remember that? I think my dad stood up and he said, this case is all about science. They say this is not a science case. The government, the prosecution, this is not a science case. Why? Because the science doesn't fit in their narrative. It contradicts their story. So they say it's not a science case. What do we have from science? Well, the 32-centimeter fundal height that they want you to question. When Skylar saw Dr. Andrew on April 26th, if you wanted to give them the benefit of the doubt, which is the opposite of the law, Skylar's the only one that gets the benefit. But take the later date of conception that they've been arguing about. They say, ignore our lead detective's report and interview with Trey Johnson, as closer in proximity to the time that they would have actually had sex. They want you to ignore it. Trey Johnson says late July, I think last week of July or first week of August. What do you say?
Overruled.
Science tells us, even taking their Dr. Latham, the femur length, average femur length, 38 to 40 weeks gestation. So take the middle, 39. When Skylar saw Dr. Andrew on April 26th, she would have been greater than 37 weeks of gestation. Greater than 37 weeks. He measured her at 32. Growth restriction is anything greater than 3. If you take their word for it, their police report, even the latter part of that, as Dr. White did, he put August 7th. He didn't go into July. He said August 7th. So you move that conception date up 2 weeks. Skylar's 39 plus weeks when she's measuring 32. What other science do they want us to ignore? We probably didn't even need science for this. Our common sense, and I don't want to continue to belabor this point, but they want you to ignore the fact that the police report that went out to the media, that they continue to make reference to this cremation and fire that you'll hear with your own ears about the fire in the interrogation. They want you to ignore your common sense and science that a baby or a human being lights on fire. Lights on fire. I mean, it is sad that they can't even come in here and admit the truth. indications of a stillbirth. It's science. It's the umbilical cord is the lifeline between the placenta and the fetus. They want you to ignore it. White. Medical term for white is pallor. So what do? Well, they bring in a DNA expert who testified well, Amy Gillard. And what does she tell us? Well, no Annabelle blood anywhere in the house, of course. And question. In fact, luminol, if cleaners are used, luminol lights up like a Christmas tree from a cleaner, not necessarily blood, right? Answer. From their DNA expert. Correct. They can light up from other things besides blood. Cleaners are a big one. Yet they continue to talk about a birth in a bedroom. And they want it both ways. But they cannot have it both ways. In fact, the law says that the only person that gets the benefit of the doubt and the presumption is Skylar. They can't have things both ways. Now, very shortly, you all are going to be back in the deliberation room. And 12 of you will be discussing what a proper verdict is. You all swore an oath to serve on a lawful jury that follows the law. And you each one of you has a right to serve on a jury that follows the law as Judge Oda gives you. And it's a right the prosecutor can't take away from you, I can't take away from you. Not even Judge Oda can take that right away from you. You each have a right to serve on a jury that follows the law and renders a verdict based on the law that Judge Oda gives you. And no other juror can take that right away from you as well. So if you're in the jury room and someone says, well, Skylar should have testified, it's improper. That's not the law. We all have a Fifth Amendment right. Knock on the door, get Mr. Mullins, and he'll get the judge. It is not proper discussion about whether or not Skylar testified. Can you do the next slide, please? You're going to have this instruction in your hand, testimony of defendant. It is not necessary that the defendant take the witness stand in her own defense. She has a constitutional right not to testify. The fact that Ms. Richardson did not testify must not be considered by you for any purpose. You saw what they did to doctors who they subpoenaed in here. You saw what they tried to do about, well, you said by hand, or you saw how they, can you imagine, one manipulative interrogation of Skylar is enough. If someone says the burden is too high, that, well, it's not fair as they suggest because of the natural decomposition process which happens when you bury people. It's not fair because the state can't prove live birth. It's not the law. The burden beyond a reasonable doubt remains the same. And you all swore an oath to follow that law. Someone says, well, Skylar took birth control or didn't get prenatal care. Again, remind that person of that jury instruction about a live birth. You cannot punish Skylar for not getting prenatal care in the 11 days after she found out she was pregnant. They mentioned yesterday on cross-examination factors that they think contribute to neonaticide. They have the burden of proof. They called a doctor in from out of state, and if they had really thought that any doctor in this entire country, a neonaticide expert, could come in here and help you all make a decision, they could have called him to the stand. They didn't do it. They didn't even call their lead detective to the stand. The prosecutors, we've all heard the statement, have your cake and eat it too. They want it both ways. And we've already talked, and I think you all know, the presumption goes to Skylar. The law says that she gets the benefit, not the prosecutors. They cannot have it both ways. So when they mention all this nonsense about, well, maybe Skylar had her in the bedroom, and then they say, but trust that the baby gurgled. They can't have it both ways. When Miss Kraft was up here talking about the 25-inch umbilical cord, and she's like, well, maybe she had her like this, standing up, maybe against a tub or against the wall. We don't know, maybe in the bedroom. But trust that the baby gurgled. Trust what Detective Carter told Skylar about 2 versus 5 minutes in the toilet. They can't have it both ways. The law says Skylar gets the benefit, not the government. They have repeatedly said that Skylar concealed her pregnancy for 9 months. It's not true. And they cannot have this both ways. Skylar did have a suspicion that she was pregnant, no question, before she went to Dr. Andrew on April 26th. And when she went, she reacted genuinely. And he said that. She was in absolute shock. They can't have it both ways, that she concealed her pregnancy for 9 months and then also have her reacting genuinely when Dr. Andrew confirms that she's pregnant. They also, as they would lead us to believe, that Skylar is sinister, evil, cold-blooded murderer and concealed her pregnancy so that she could kill Annabelle, but then reacts genuinely to the doctor and goes back to the same group. You can't have it both ways, and the law says they can't. Skylar gets the benefit. Dr. Andrew, Ms. Kraft mentioned this in her closing about suicide warnings. You heard Dr. Andrew. You heard him. He said he gives the same information that he gave Skylar to every pregnant woman in her 3rd trimester. They say, trust Skylar when she says kind of big. Trust that, but ignore the 30 times she describes a dead baby. Ignore the 17 times she denies there's a fire, but trust that she says kind of big. Skylar had never given birth before. She gives birth into a toilet with 1-inch water, and a body comes out of her. Of course, Annabelle looked kind of big. My wife gave birth to my daughter on March 2nd of this year. And I had never seen a live birth. And this was 6.5 months ago. My wife was in the hospital with great care, wonderful OBGYNs and nurses around her. There was fetal heart rate monitor. She did not have 6 years of an eating disorder. I can tell you she was not growth restricted. I knew she was pregnant. You could tell. And had the doctors not reacted quickly with a heartbeat monitor they were following my daughter's fetal heart rate, my daughter wouldn't be here today. And when they did an emergency C-section on my wife and pulled my daughter, Johanna, out of my wife, she was blue and purple, and I didn't know. I didn't know that that's what babies are supposed to look like, and I was scared until she let out what Dr. White said is the miracle of life, that wail. The state spent 2 weeks proving that Skylar didn't mourn the way they think she should have mourned. She was texting 2 people who had no idea that she was pregnant. Her mom might have had a suspicion, but didn't know. And Skylar didn't want to talk to her mom or boyfriend about her stillbirth. They didn't know. That doesn't mean she wasn't grieving inside or hurting. Skylar, anytime she had something tragic happen in her life, she focused on the only thing she thought she could control in her life, which was her body and that eating disorder that took over. So they proved that Skylar had a serious eating disorder and didn't mourn the way that they think she should have mourned to her mother and her boyfriend, who didn't even know she had had a stillborn. We know, in this case, from their witness, Dr. Latham, no signs of trauma, no signs of violence, no burning. Their witness, Dr. Latham. We know from Professor Hirsch, false confession expert, the Reed method, Reed technique, how susceptible a person can be who is naive, vulnerable, and suggestible. As Dr. Bassman told us, the Reed method creates false confessions, and valid ones. And we don't even have to take Dr. Bassman's word for Skylar's suggestibility. We heard from friends and teachers and counselors. You could see her in the interview like a 12-year-old holding Officer Gee and Detective Carter's hand, begging for their hands, asking for a mom. We have proven statements that she made to the detectives false. We know they're false. In our hearts, they know it in their hearts. Dr. White testified, a well-respected obstetrician who's never testified in a criminal case before. He testified. He said to a reasonable degree of medical certainty, Skylar had a stillbirth. Their doctor just, I don't have enough information, so I disagree with Dr. White. I'm not going to play the interrogation techniques. I'm sorry, the interrogation tapes or clips. Thankfully, you've all seen them now, and you will have them. You will have those in the back when you're deliberating, and you can watch them in entirety, in part, however you choose. And I'm glad that you now have them in their entirety so that they can be put in total context. What you won't have, you won't be able to get at any point, unfortunately, and this is normal in trials, the testimony from all the other witnesses. Trust yourselves. You guys, you've been paying great attention, taking notes. Even those who are not taking notes, I know you're paying a lot of attention. Trust your memories, because you can't, the judge won't give you transcripts of prior testimony or a video of prior testimony. So trust each other, trust what you heard. Don't take it from me, don't take it from the prosecutor. Trust what you heard. Just a few more things before I sit down. If you're back there, a compromise is not a verdict that follows the law. A compromise. Meaning, well, even though we have reasonable doubt as to the live birth, we think Skylar should be convicted of child endangering because maybe it's 10-2 to acquit on aggravated murder, so maybe we just compromise and just look at everything as a whole. Each count has to be looked at separately. And if you have reasonable doubt on the live birth, the first three counts must be not guilty. Can you do the next slide, please? And this is the instruction that you'll get on that. Consider the counts separately. The charges set forth in each count in the indictment constitute a separate and distinct matter. Except as to the count of involuntary manslaughter, where I already provided you specific instruction on this point, you must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all the offenses charged. It's essentially don't compromise and look at this as a whole. The fourth count, you have 4 charges, is abuse of a corpse. And it is still a very serious felony. A conviction on that would label Skylar a felon. And the instruction, I think the prosecutor did read you the instruction on that count, is that her conduct, that's the key, her conduct offended the outraged, reasonable community sensibilities. I agree the community's been outraged. But they've been outraged because for more than 2 years, the prosecutor's office and the detectives have said, we don't know if Skylar burned her baby alive. She said she lit her baby on fire. So ask yourself why they've been outraged. Because reasonable doubt is so crucial when someone's liberty is at stake, I want to do one other example of what reasonable doubt feels like. And imagine with me you're in the back. You're in the deliberation room. 12 of you are sitting around the table, and you're talking about what a just verdict is, and you're looking at the law that Judge Oda gives you. And you get a knock. And Mr. Mullins gives you a disc. And he puts it in the middle of the table, and he says, we just received this, ladies and gentlemen. It's a video recording of the Richardson household on the early morning hours of May 7th. He just puts it on the table. If you reach for this to play it, you have reasonable doubt as to what occurred. Period. That is a not guilty verdict on those first 3 counts. That's what reasonable doubt feels like. Next slide, please. Conduct while deliberating. This is my last instruction that I'll read. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgments. Each of you must decide this case for yourself. You should do so, however, only after discussion of the case with the other jurors. You do not hesitate to change your opinion if convinced that it is wrong. You should not surrender your considered opinion concerning the weight of the evidence, however, in order to be congenial or to reach a verdict solely because of the opinion of other jurors. So if you are not firmly convinced, if you have a reason to doubt the live birth, you have to fight for Skylar. I don't belong in the jury room. And I'm sure you all are probably glad that we're not going to be back in the jury room. And this is the hardest part of any case, and that's passing the burden of Skylar onto you. I trust you'll find her not guilty.
Ladies and gentlemen, shortly after murdering her daughter and placing her lifeless body in the dirt behind their home, Brooke Richardson sent 2 elated text messages to her mother that both contain the phrase, "My belly is back. My belly is back." Ladies and gentlemen, that belly was her child. That belly was her daughter, a daughter with fingers and toes, with hair on her head. A child that she tossed into the dirt and didn't even have the decency to wrap her in a blanket to show at least some semblance of respect for that baby girl. A child that meant absolutely nothing to her, as evidenced by her text message just hours later. I'm literally speechless with how happy I am. This photo of Brooke was taken the same day that her daughter died. The same day. So it's easy for her now to come in here and portray herself as someone that loved her daughter and would never hurt her daughter. But we know that that is absolutely not the truth. And we know that because of her statements and her actions before her daughter's death and afterwards. Let's first talk about some of the defense arguments that have been put out in this case. And one of them, they didn't discuss it here in closing arguments, but it's the theme they've tried to weave in, which is she had 10 weeks. She thought she had 10 weeks to tell everyone about what was going on. But we know that's not true, don't we? when she was specifically asked in her first interview about how far along she was, she said she had no clue. She stated, "I'll be completely honest. I didn't listen. I didn't hear." And when asked again, Brooke stated, "I don't know how many weeks I was." And when she was asked, could they have told you maybe 32 weeks? She said, "Maybe. I know that I was far along." So to come in here now and suggest she thought she had 10 full weeks to tell everyone what was going on, that's completely inconsistent with the facts that we know in this case. And remember, our statements are not evidence. The evidence comes from the witness stand and the evidence that's presented. And there has been no evidence to suggest that she thought she had 10 weeks to finally come clean and tell everyone. And if she were going to come clean, what better time than a couple of days after the appointment when her mother gets the email from Hilltop OBGYN that says that she's pregnant. And her mom specifically asked her, "What's this mean? Are you pregnant?" She knew she was pregnant at that time. She knew she was far along. Don't you think if you were going to come clean, if you were going to tell somebody at the point that your mother's specifically asking about it and you know that it's going to happen, that's when you would talk about it if you were ever going to do that. Another argument that the defense makes is that Brooke's daughter was IUGR and was subsequently a stillbirth. There are numerous flaws with this argument, ladies and gentlemen. First, the diagnosis of IUGR was purportedly made based on one measurement in time, just from that April 26th visit with Dr. Andrew. But as you heard, the only way that you can diagnose IUGR is to have multiple measurements over a lengthy period of time so that you can track the baby's growth. With just one measurement, you have nothing to compare it to, so you don't know whether there's a lag in the baby's growth or not. And that's not coming from me. That's coming from Dr. Brady, the maternal fetal medicine specialist, the specialist that Dr. White, their doctor, sends his patients to consult with if they're a high-risk pregnancy. That's what Dr. Brady told you. And he told you from the information that we had, you can't diagnose IUGR, and you can't say that this child was a stillbirth. In fact, he told you that given her blood work and the information that he reviewed, he would expect that child to still be healthy 2 weeks later at the time that Brooke delivered. It's also interesting in this case that their doctor, Dr. White, issued two separate reports. If you remember, the first report said likely complicated by IUGR and significant likelihood of stillbirth with a conception date of August 21st, 2016. But apparently that wasn't good enough for defense counsel, because less than 2 months later, all of a sudden here comes another report. And this report's a lot more specific. This says definitely stillbirth and definitely IUGR. And now the conception is back in July, when both Brooke and Trey agree they weren't even seeing each other at that time. They didn't have sex until the middle of August. And this is the same doctor who came in here and told you that one of the really significant factors for him in reaching this stillbirth conclusion was how she described the child as really white. Do you all remember when he said that? It's like, oh, it was really white. And she wouldn't have known that. So this really white, that was really significant to me. But that's not what Brooke said. Fortunately, we have the interview. And you're going to have both interviews back there. The only time that Brooke was ever asked about what color the baby was she says, white, I think. And they follow it up. Like, what about her fingers or toes? Did you see any of that? Like, what color was that? I don't remember. This is what we're basing a stillbirth diagnosis from? White, I think? Are you kidding me? Again, you have to look at people's credibility. You have to assess their qualifications. Dr. White is a general OBGYN who says that on his second go-around, second report to defense counsel, he can say this baby is a stillbirth. And you have Dr. Brady, a maternal fetal medicine specialist, who says that that diagnosis of IUGR cannot be made based on the information that both doctors reviewed. And finally, the last point I want to make about this IUGR is that the only person who ever saw this child after she came out of the womb was Brooke Richardson. She's the only person that ever saw this child. And this is someone who worked in child watch and someone who has watched 6-week-old babies of all sizes, big, medium, small. And how did she describe the size of her own baby? If you remember, she even sounded a little bit surprised when she was asked about it. When she was asked about the size of the baby, she said she was kind of big. But what did Dr. White say about that statement? He said that he didn't really give any weight to that statement. Why? She has experience working with babies. Even Brooke, with no medical experience whatsoever, knows whether a baby is big or not. And the funny thing is, when most people see a baby, when they look at them, a new infant, what do they always say? What's the common reaction? Oh, they're so small, they're so tiny. Not Brooke. She was kind of big. But the doctor discounted that statement from the only person that ever saw the baby alive. And you want to know why he discounted it? Because it didn't fit their narrative. It's hard to come in here and say that this was an extremely small IUGR baby if the baby is kind of big. But he was willing to give weight to all of the other descriptors that Brooke was willing to give about signs of life or a lack of signs of life. And he was willing to come in here and accept Brooke's diagnosis that this child was a stillborn, but not rely on her statements about whether the child was big. Again, this doctor simply discounted the things that didn't fit their narrative and only tried to latch on to the things that did. That's not reliable. That's not to any reasonable degree of medical certainty. And Dr. Brady, the maternal fetal medicine specialist, called him out on it. Another argument is that this case is the result of a false confession. They even brought a false confession expert in here to tell you about techniques that can lead to false confessions. But what did he really have to say? He said, when you're looking at a statement, you evaluate it with all of the other circumstances surrounding the crime. That's just telling you to use your common sense, ladies and gentlemen. And when you view the statements made by the defendant in the context of the other information that we know, that she didn't want her child, that she looked for ways to get rid of her child, that she disposed of her child in the backyard without telling anyone, there's no question that her child was born alive in the early morning hours of May 7th. Another big argument from the state or from the defense is the state's expert got it wrong about the charring of the bones of the infant. First, this anthropologist wasn't one of the state's experts. She was hired by the coroner's office. And the coroner's office is not even affiliated with the state. And she did get it wrong about whether there was evidence of burning on the bones. But the state never hid that fact. As you saw, that was provided to defense counsel. And then additionally, the state went out and retained their own expert to get an objective opinion. And that report was turned over to defense counsel. And then we actually called her to the stand so that you could see her testify. And when she was called to the stand, she said the same thing as all the other experts. There was no evidence of charring to the bones. That doesn't mean that there wasn't some evidence of burning to the tissue, and that because of Brooke's deliberate actions of burying the baby in the yard, we can't say anything with respect to a medical or scientific cause of death. That's what all of them have said. So you have to look at other circumstances. They also want to talk about that the anthropologist says there's no identifiable trauma to these bones before the baby died. But again, that conveniently leaves out that she also told you, just from looking at the remains, which is all we were left with, you can't say if a child was drowned. You can't say if a child was suffocated. No one was alleging that this child's skull was smashed in. Rather, the most obvious cause of death here would be drowning or suffocation in order to silence the baby as soon as she came out. There's a suggestion here that there's reasonable doubt due to the lack of scientific or medical evidence. The reason that there's no exact medical or scientific cause of death is because of the deliberate actions of the defendant. The defendant's entire purpose of concealing her daughter and burying her in the backyard without telling anyone was so that no one would ever be able to run a test on that child. That was her purpose. So now to come in here and ask to be rewarded for that fact, to be rewarded for the fact that she was able to conceal that child for 2 months in the ground, that's unbelievable. So if you're back there in the jury room having discussions about the medical and scientific evidence regarding the cause of death, remember why you don't have that evidence. Remember who's responsible for that. It's not the state of Ohio.
Objection, Your Honor. He's implying
Overruled.
It's the defendant, Ms. Richardson. And you'll get an instruction from the court. It's called a consciousness of guilt instruction. And if you find that she concealed this evidence to hide evidence of the crime that she committed, you're allowed to consider that when making a determination about her guilt or not. So as we talked about in voir dire, you have to look at all the surrounding circumstances. And all of the surrounding circumstances and her actions point to this child being alive. Now let's talk about their expert psychologist, Dr. Bassman, who testified yesterday. In his first assessment that he did with Brooke, the assessment concluded that her primary concern in terms of her intense fear of rejection and disapproval and abandonment was related to her family. That assessment was based on the self-reporting by Ms. Richardson. But did you notice in the report that he tried to submit to the court and he tried to give to all of us? He changed that, didn't he? He changed the language from family to authority figures. And he tried to say that this fear of rejection and disapproval was so significant that she would just agree to whatever law enforcement was saying to her because she was so afraid. But we know again that this assessment and her fear were with respect to her own family. So you have to ask yourself, why did he make that change and come in here and try to suggest to you that it related to authority figures when he knew, they knew, that it related to her fear from her mother and Brandon? And this wasn't just a regular fear. The doctor says that she had an intense fear of abandonment, disapproval, and rejection by her mother and by Brandon, the two people that mattered the most to her. And I have to tell you, I absolutely agree with that. I do believe she had an intense fear regarding that. And because of that fear, she would engage in extreme behavior if she was under a significant amount of stress. And we know she was under stress at that point. She was pregnant by a boy that she wanted nothing to do with. She was terrified of losing Brandon. And she was so fearful of her mom's disappointment in her if she were in fact pregnant. Her stress was through the roof. And as a result, she engaged in extreme behavior due to her fears of being rejected and abandoned by the two people that mattered most to her. And that fear of disapproval, that relates to all of the character witnesses that came in here as well. They all told you that she had this image of having the perfect life. Only Brooke knew that at that time, her walls were crumbling around her. And because she wasn't willing to risk losing that perfect image, she engaged in extreme behavior, just as Dr. Bassman said that she would. Finally, what else did we discuss with Dr. Bassman's testimony? There was discussion about the fact that he didn't even consider that she was displaying all of the traits of someone who commits neonaticide, which is the killing of an infant on the day of its birth by mothers who deny that they are pregnant and cause death by suffocation, drowning in the toilet, or strangulation. And he told you he was familiar with the author of that article, Dr. Resnick, and he was even familiar with the term neonaticide. And Ms. Kraft discussed all of the factors that go into play of a neonaticide killer. Younger, late teen female, check. No psychotic symptoms or psychosis, check. No criminal history, check. No attempt at abortion, check. No relationship with the father of the child, check. Inability to reveal the pregnancy to her mother, check. Child is an obstacle to parental goals, check. Child not wanted, check. Denial of pregnancy, check. Gave birth alone, at home, with other family members present in the home, check. And what did Dr. Bassman say when confronted with all these factors? He commented that it appeared to be an old article. And then he was shown a peer-reviewed, scholarly article from 2010 examining the 40-year history of neonaticide. And so you have to ask yourself, why didn't he take those factors into consideration when he was looking at her personality traits? So let's talk about the facts in this case that show that she murdered her child. As we've said all along, this case is based on circumstantial evidence. And if you remember from voir dire, there's a difference between direct evidence and circumstantial evidence. Direct evidence is an eyewitness to the crime, somebody who saw what happened and can take that witness stand and tell you, I saw Tommy hit Joey. That's direct evidence. Circumstantial evidence is when you look at all of the surrounding facts and you're able to infer the existence of another fact. In this case, there is no eyewitness that can tell you that they watched Brooke Richardson kill her daughter. She didn't tell anyone. She didn't wake anybody up. So this is a circumstantial case. But remember, direct evidence and circumstantial evidence are to be weighed equally. They carry the exact same weight. So you can't just go back into the jury room and say, I just want to look at one thing to tell me whether she killed her child or not, because that's not how a circumstantial case works. You have to look at all of the surrounding factors when making your decision. You have to look at the entire picture. One of the best ways I like to look at circumstantial evidence is to compare it to a puzzle. When you're putting together all of the pieces of a puzzle, you can start to form the big picture even before that puzzle is formed, can't you? And even when you're getting close to having that puzzle put together, even if you're missing a couple of pieces of the puzzle, you're still able to determine what the picture is, what's being depicted in the image. That's the same concept as circumstantial evidence. From looking at all of the surrounding circumstances, are you able to conclude what happened in the case even if you do not have every single fact? And from looking at all of the circumstances, can you put the puzzle together? Can you make the picture? So let's look at this puzzle and see whether, when we put all of the pieces together, you have a clear idea of what happened. What's the first pieces we're going to start with? What do we know right at the outset? We know that she didn't want the baby. We know that because it was an unwanted pregnancy. She only had a very brief relationship with Trey. She stopped talking to him, hadn't seen him since August. So that's one thing we know. We know she had an intense fear that her boyfriend Brandon would leave her because she was pregnant. And that's not me saying that. You know the best way to know what somebody's thinking, ladies and gentlemen? It's to look at their text messages, to see what's going on in their mind at the time. And what did she text Brandon after her secret was exposed? She said, "I love you. I'm so sorry that I never told you. Please understand that I was scared and worried and so scared of losing you." Third, she specifically told us in the very first interview she didn't want this child. She stated, "I didn't really want to have my baby, but I couldn't get rid of it." So these are the very first pieces of the puzzle. The understanding that unquestionably she did not want that baby. The second piece of the puzzle then is that she looked for ways to get rid of the baby. And that makes sense. That follows naturally from the first pieces. If she knew that she didn't want the baby but couldn't get rid of it, she needs to start looking at ways. Is there anything I can do to get rid of it? And we know that she did that because she told the detectives that. She said she researched how to have an abortion without going to the doctor. She said she looked at ways and researched ways of how to get rid of a baby. And when the detective even asked her, like, "So when you say that," and she's like, "Geez, that sounds really bad, doesn't it?" Yeah, it does. And we know that she did it because she knew there were ways that she saw. She told the detective there was like, it gave you different things to do, and like different pills or different things to do, and like different ways, but I never did any of those things. Clearly, she looked up these things. All of those things don't just come up by typing in a search in Google. She had to go to the actual websites to see them. And we know then that she deleted the contents of her phone. You have to ask yourself, why would she do that? Why did she delete all of the searches? Why did she delete all of the text messages between her and Brandon and her and her mother? What was she so afraid of? The next piece of the puzzle relates to her fear to tell anyone that she was pregnant. She was told repeatedly by her doctor to tell someone about what was going on, but she was adamant that she could not. And so she kept this secret all to herself, feeling trapped and feeling isolated, and feeling so desperate that she started researching how to get rid of a baby. And she already knew what her mother's reaction was going to be. She knew that because her mom told her in a text message. When her mom thought she was pregnant, she said, "It would ruin your life. It would ruin your future." Think about what effect that has on someone who has an intense fear of disapproval from her mother. To go along with keeping her secret inside, the next piece of the puzzle relates to her planning and preparation for the child, which there was none. She never followed up with Hilltop OBGYN. She never started her prenatal care. She didn't look for anything for that baby. She didn't have a car seat. She didn't have a crib. She didn't have any of the things that you would expect an expectant mother to have. She didn't even have somebody lined up to take care of the child if she decided that she wanted to give it up for adoption. She had done nothing. Another big piece of the puzzle is the defendant's actions in the concealment and destruction of evidence after her daughter's birth. What do we know? First, we know that she buried the baby so that no one could do any testing on the child. What else do we know? She got rid of the towels and the mess. And what's interesting here is when her dad asked her about that, he says, "Did you throw it away at our house or someplace else?" And what was Brooke's response to him? It was someplace else. Why would you do that? That shows a level of thought and planning that you wouldn't expect from just a scared teenager that purportedly had a stillbirth. Additionally, she moved her bed to cover that large blood stain. And she doesn't move the bed until after her first interview with the police on July the 14th. Sometime after that interview, she moved her bed. And this movement of her bed directly covers a large blood stain with her DNA and a minor component of DNA from someone else. But there wasn't enough to test it. And you have to remember, where did Dr. Boyce say that Brooke first told her she delivered that baby? Dr. Boyce, when she was interviewed by Detective Carter 2 days after her appointment with the defendant, she acknowledged that she told the detective that Brooke told her she delivered in her bedroom. And look at the placement of the stain in relation to where her bed was at that time. And consider the picture that Deputy Smith said appeared to be a torso right on that spot on the floor. They can come in here all they want and say, well, she said cleaning fluid can also lighten up luminol. But what else do we know? What was conveniently left out of that from Amy Dallaire? She tested this. That swab, that area where it's lit up, it was tested. And it came back as blood. This wasn't cleaning supplies. This was specifically tested. And it came back as blood. And the DNA on it was Brooke Richardson's and a minor component that there wasn't enough to test. Next, we have her bloody footprints from going to the bedroom in the direction towards the bathroom. And why is that significant? Shows you that she's been lying about this from the very beginning. And if she made up her mind to lie about where the delivery occurred, you have to ask yourself why. Why would she make that up? And you have to then wonder whether you can trust anything that she says. Why lie about the location of the birth of your daughter if it was a stillborn? What would be another piece of the puzzle that you would want to look at? You'd want to look at her mood and feelings afterwards, wouldn't you? So first you have her reaction that she tried to show to the detectives, where she's crying and she's like, I loved her. I would never harm her. So that's one reaction that was presented to you today. But compare that to the text messages that she wrote before any police involvement in this case, back when she thought she got away with the whole thing. What does she say? I'm literally speechless with how happy I am. My belly is back, OMG. I'm never, ever, ever, ever letting it get like this again. You're about to see me looking freaking better than before, OMG. That was just hours after her daughter died. An hour after that text message comes another one. I'm literally so excited now just for dinner to wear something cute. Yay. My belly is back. Now I am taking this opportunity to make it amazing. The defense has tried to make this suggestion. She sends these kind of text messages all the time. But that doesn't make any sense. What's her belly back from? She specifically says, my belly is back. Her belly is back because her child is no longer there. And she is thrilled about that fact. She then sends another text message to Brandon, same morning after her daughter's dead. I'll tell you about it later, but last night was like the worst ever, and I didn't go to sleep until 5:30. But I feel so much better this morning. I'm happy. One day after putting her daughter in the ground, she sends another text message. Great. I feel like a literal new person. I'm confident and happy. I have been strutting down every hallway, killing it, and have been thinking about how awesome I'm going to look this summer. Think about those texts. Which do you think more accurately reflects her feelings? The crocodile tears in the interrogation room when the police are talking to her about it, or the text messages when she thought she had gotten away with it? Which do you think is the better representation of her feelings at the time? Your Honor, can I ask you how much time I have?
You have until 10:47.
Okay, thank you. Another piece to the puzzle. She never told anyone about her child after its death. If it was truly a stillborn, why not tell your mother? If it was truly a stillborn, why not go to the doctor and get checked out and examined to make sure that you don't have any injuries or complications? The defense argues, well, she went back to the same practice. She was ready to disclose that day. She was ready to come clean. But we know that's not the truth. She didn't go into that doctor's office wanting to disclose. She only said that when she was confronted. And even after she was confronted, she still told Dr. Boyce that she didn't want her mother to know. If it was up to the defendant, Dr. Boyce would have never called the police, and that child would still be 2 inches in the dirt back behind their home. So let's not all pretend that on July the 12th, she was ready to come clean and tell everyone and get this burden off her chest, because we know that's not true. So we have all of these pieces of the puzzle, and now the image is really starting to become clear, isn't it? What do we know? She didn't want it. She couldn't get rid of it. She researched ways to get rid of it. Never told anyone about it. Lied and concealed it. No preparations or planning for it. Upon having it, buried it in the backyard. Destroyed and disposed of any evidence of it. Was happy after it died. And never told her family about it after its death. And ladies and gentlemen, the reason I'm using it here as opposed to Brooke's daughter is because that is how Brooke described her daughter throughout the entire first interview. You'll have that. Go back and watch it. Every time she talked about her daughter, it was it. It wasn't until the second interview, after the police were involved, that all of a sudden her daughter had a name, and it was Annabelle. So when you have all of those pieces of the puzzle, you can see what's happening here. But we haven't even got to the final piece yet. The single most insightful piece of evidence in this case. And that's the 5 minutes leading up to her daughter's birth. She knew she was going to deliver. She told the detectives that, and she told Dr. Boyce that. She knew what was happening. She'd been having contractions since the Friday. And so what happens in the minutes leading up to her daughter's birth when she knows that baby is going to come out and she can't conceal it anymore? What does she do? Because this is how you know what her true intentions were. She didn't call 911. She didn't go to the hospital. She didn't wake up her parents. She didn't wake up her brother. So you have to ask yourself why. What would be the point of that? Of not requesting help at that point when you know you were giving birth. You are at that point, you know you can't conceal the baby anymore. And you don't still know at that point when she was getting ready to deliver, she doesn't know if she's going to deliver a live baby or not. You would think she would have to assume this baby's going to come out alive and it's going to start making noise. So why not get your parents? That's certainly better than knocking on the door and waking them up as you're holding this baby. And not only did Brooke not ask for help, but she committed herself to staying quiet during the entire labor process. Why? Why was she so motivated? And that was not my word. That was Dr. Boyce's word. When she talked about labor being a horrific process, she said you would have to be motivated to stay silent through it. So what was her motivation to stay so silent when she knew that she was going into labor? There's only one reason that you wouldn't ask for help at that point. Only one reason you would force yourself to give birth in silence. And that's because that child was never going to see the light of day. And that decision is confirmed when you look at her actions immediately following her birth. She's never delivered a baby before. She doesn't know what a baby's supposed to look like. So if this child came out not breathing, as Brooke would have you believe, why is she not trying to get it help? What mother doesn't think that they want to get help for their baby immediately upon her birth if she thinks something's wrong? Brooke's not a doctor. She has no medical training. This is someone who the defense contends didn't even know she was pregnant until 8 months. But now we are going to accept her medical opinion of a stillbirth? You have to be kidding me. Any mother in that situation, if they believe that their baby is in trouble, if they believe that their baby is in danger, would be begging for help. They would be screaming to anybody that would listen, please come help my daughter. That's if you truly wanted to save her. What does Brooke do? Nothing. She doesn't call for help. She doesn't wake her parents. She doesn't do anything. She doesn't even engage in any life-saving measures for the baby. She did nothing. And when you look at all of those pieces of the puzzle, ladies and gentlemen, you're able to see the big picture now. You're able to know exactly what happened in this case. The puzzle shows you exactly what happened. The evidence shows that she clearly murdered this child. There is no other explanation for all of her actions and inactions. But even if some of you are back in the jury room struggling about whether she purposely murdered her daughter, there is no question, none, that she is guilty of involuntary manslaughter and endangering children. There can be absolutely no excuse for not helping her daughter after that child was born alive. Even if you accept the argument that the child was in distress upon birth, everyone can agree that she should have tried to get that baby help. She should have called 911. She should have got her parents. She should have gotten medical assistance for the child. There can be no reason, no justification for just lying there and not lifting a single finger to help her. And this wasn't just a stranger to the child. This was her mother. And she didn't do anything. She medically diagnosed her as a stillborn and buried her in the backyard without telling anyone. At a bare minimum, this is endangering children and involuntary manslaughter. No question that she violated her duty of care, protection, and support to her daughter. But this was about more than just not getting her daughter assistance. This was about ending her daughter's life. Brooke's decision not to ask for help when she was going into labor and her motivation to remain quiet during the birthing process proves this child was never going to be allowed to live. She didn't just get lucky that a child that she didn't want, made no plans for, and told no one about, just happened to come out stillborn in the middle of the night under the cover of darkness. This is someone who actively researched how to get rid of a baby and then made it happen by killing her and burying her in the backyard. And now she comes to you when she's caught in her web of lies and deception, and she asks you to believe that this was all just luck. All of the stars didn't just align, ladies and gentlemen, for her to have a stillborn child that she didn't want, told no one about, made no preparations for, and concealed and buried her in the backyard, all so that she could maintain the appearance and the image of her perfect life. That's not reasonable doubt. That's not doubt based on reason and common sense. That's ridiculous. That would be holding us to a standard of proving this case to you beyond all possible doubt, which the judge will tell you is not the standard. It's beyond a reasonable doubt. And are you firmly convinced of the truth of the charge? And ladies and gentlemen, if you want to know how Brooke Richardson truly felt about her daughter, don't take it from me. Don't take it from Mr. Ritkers. You don't even have to look at the interrogation tapes. If you want to know how she truly felt about her daughter after just putting her in the ground, what was her reaction before she was ever charged, before she ever spoke with the police, back when she thought she got away with everything? How did she feel? I'm literally speechless with how happy I am.
Ladies and gentlemen, you've been sitting for about an hour now, so if you want to get, well, close to 2 hours now, so you can stand up, move around, stretch out a little bit. As you do, Mr. Mullins is going to distribute to you the jury instructions. In the 14 years or so that I've been a judge, it's been my experience that different people absorb different information in different ways. I'm going to read you the instructions of law in this case. You are also going to have a printed version of what I say. If you are one of these people that likes to follow along and read along, then you can follow and read along. If you are one of these people that would prefer just to listen, you can do that as well. The one thing that you can't do is sort of flip ahead and see what is coming next. You will have these instructions with you in the jury room, and sometimes I have a tendency to ad-lib, which means I will leave my prepared remarks. I will try to let you know when that is, and also when I return. So if
come back on screen. And there you have it, ladies and gentlemen. You heard both sides. You've heard the prosecution painting Brooke Skylar Richardson as, well, what's the best way I can put this? An evil young woman who never wanted to be pregnant in the first place. And you've heard the defense motion, the defense argument said, who's going to paint Brooke Skylar Richardson as we saw her in the courtroom. A scared young lady who didn't know what she was going to do when she got pregnant. So, 13th juror, I'm asking you now, what is your verdict on the charge of aggravated murder? How do you see her? On the charge of child endangerment, on the charge of involuntary manslaughter, on the charge of abuse of a corpse. I already have my verdict in mind. I would love to hear yours at some time. You can drop your verdict in the comments. You can email me your verdict, or you can hold it in as we get set to hear from the jury themselves. Okay. We are now at the point where Brooke Skylar Richardson's fate is in the hands of the jury. So we're going to go there right now.
All right, this is the case of the State of Ohio versus Brooke Skylar Richardson, 2017 CR 33292. We are on the record outside the presence of the jury. Ms. Richardson has waived her presence for the reading of the question. Is that correct, Mr. Richters?
Yes, Judge.
All right, the question from the jury reads as follows. Can we please have a simplified definition of, quote, abuse of a corpse, end quote? New paragraph, is it against the law, and LAW is in all caps, to bury a body in your yard without knowledge, question mark. Mr. Knippen, Ms. Kraft, anything from the state?
The state is in agreement with the judge's proposed response, Your Honor.
Well, my proposed response is the court cannot provide you with any other or alternative legal definitions in the case. You need to refer to the written instructions that have already been provided. I should have read that first.
The state's in agreement with the proposed instruction, Judge.
Mr. Richters?
So is the defense, Your Honor.
All right, I will send this question back to the jury. We are in recess for the answer.
Call the police court is now in session. The Honorable Judge Oak presiding. You may be seated.
Court has been advised that we have a verdict. Are we ready for the jury?
Yes, Your Honor. Yes.
All right, Mr. Mullins, go get the jury. You may be seated. Who has been selected as the foreperson for our jury?
I have.
All right, ma'am, has the jury reached a verdict in the case?
We have.
Without disclosing the nature of the verdict, were you able to follow, was everybody able to follow my instructions while you were deliberating?
Yes, sir.
Were you able to remain free from any outside contact, communication, or influence during the deliberation process?
Yes, sir.
All right, please hand the verdict forms to Mr. Mullins. In advance of the reading of the verdict, I want to thank each of you for your service. After this, you will be discharged from your service. You'll be returned to the jury room, reunited with your electronic devices. I have a couple of minutes that I would like to talk to you, and then we will get you on your way. You will be able to speak with anybody about the case that you would like, but you are not required to do so. Whether you decide to speak to anybody is a matter of your own free choice. Would the defendant please rise? With regard to count one, we, the jury in the above captioned case, find the defendant, Brooke Skylar Richardson, not guilty of the offense of aggravated murder, and there appear to be 12 jury signatures affixed. Verdict form 2, involuntary manslaughter. We, the jury in the above captioned case, do hereby find the defendant, Brooke Skylar Richardson, not guilty of the offense of involuntary manslaughter. Count 3, child endangerment. We, the jury, find the defendant, Brooke Skylar Richardson, not guilty of child endangerment. It does say we further find the defendant did not cause serious physical harm to the alleged victim, but that finding is not necessary as a matter of law. Verdict form number 4, we, the jury in the above captioned case, find the defendant, Brooke Skylar Richardson, guilty of the offense of abuse of a corpse. Ladies and gentlemen, are those the verdicts of the jury?
Yes, sir.
You may be seated. All right, again, you are now discharged from all your service. Does either side wish to have the jury polled?
No, Your Honor. No, Your Honor.
All right, ladies and gentlemen, you will now be returned to the jury room. Thank you for your service. Mr. Mullins is going to give you back your phones and such, and I will see you in a couple of minutes. You may be seated. We are on the record outside the presence of the jury. Anything additional from the state?
No, Your Honor.
Anything additional from the defense?
No, Judge.
The court will order that the verdict forms be filed. I will draft an entry accepting the verdict forms. I'm going to set this matter for sentencing tomorrow at 11 o'clock. I will order a pre-sentence investigation between now and then. So court services will conduct a pre-sentence investigation. They can tell me that they can get that done between now and tomorrow. Bail for the defendant is hereby revoked pending sentencing. We'll see everybody tomorrow at 11 o'clock. That's all.
So there you have it, folks. The verdict is in. Brooke Skylar Richardson, not guilty of aggravated murder, not guilty of child endangerment, not guilty of involuntary manslaughter, but guilty of abuse of a corpse. Does anyone here agree with that verdict? Again, let's see. Oh, wow. Already, I have one calling her guilty. Tammy, on which charge? On which charge, Tammy? Is it the aggravated murder? Was the aggravated murder, the child endangerment, involuntary manslaughter, or the one that she was found guilty of, abuse of a corpse? Believe it or not, if I were a betting man, I would have went the same route as the jury did. In the meantime, while we're gonna go right directly to Brooke Richardson's sentencing, and immediately after that, I'll give you the aftermath. Okay, I'm gonna dip out of here. I'm gonna give you over to the sentencing of Brooke Skylar Richardson on the charge of abuse of a corpse. But like I said, if I were a betting man, I probably would have went the same way because, but then again, I'll explain why. But I'll give you the aftermath.
This is the case of the State of Ohio versus Brooke Richardson, case number 2017 CR 33292. Present before the court is Ms. Richardson, right?
Yes, Your Honor.
Represented by Mr. Rickers and Mr. Rickers. We have Mr. Knippen, Ms. Kraft on behalf of the prosecutor's office, Officer Bittinger on behalf of probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, Judge.
Any reason we should not go forward with sentencing today?
No, Your Honor.
No, Judge.
The defendant was convicted yesterday of the abuse of a corpse charge, which is a felony of the 5th degree. The maximum punishment is a $2,500 fine and 12 months in prison. Counsel, we agree that this is a mandatory community control case, right?
Yes, Your Honor.
What that means, Ms. Richardson, is because this is a felony of the 5th degree and you have no prior criminal record and you don't fit the other statutory criteria, the most, I am required by law to place you on community control. That's what we used to call in the old days probation. That means that the maximum that I can sentence you to today, even though the maximum for this offense is 12 months in prison, the maximum that I can sentence you today is to 6 months of local incarceration. That means in the county jail. We have 7 days of jail time credit. I think one thing it's important to point out, Ms. Richardson, before we get started with the trial or with the sentencing hearing in this case, is that in the entire time that this case was pending, back when it started, I set a bond, and that you've been sleeping at home while this trial has been going on, and you've been out and about. I know that there was some angst about that, but the reason I do set a reasonable bail in a case is because you're presumed to be innocent. That means that you haven't been convicted of anything, and you have the right to a reasonable bail. Yesterday, after you were convicted of the felony, even being a low-level felony that it was, you're no longer presumed to be innocent. And while it's fair that you would be out in the community while we figure out what's going on with the trial, when you no longer have that presumption of innocence, it's fair that you be in jail until we figure that out, which is why we are here today. I think one other point that bears mentioning at this point is, I'm not sure it's really relevant to what we have going today, but this has been an extraordinarily high-profile case, and lots of people in the community are talking about this case, whether it be in their workplace, posting about it on the internet. It seems like everybody has an opinion on the case. I think about everybody in Warren County has the Court TV app on their phone now, which means that everybody knows about this case. Prior to us beginning this case, the court undertook a cooperative effort with our friends in the media to make sure that the trial of this case, not all the gossip, not all the press conferences and what goes on in the hallway, but the actual presentation of the evidence and the arguments of the lawyers was available for everybody to see. I allowed the cameras in the courtroom, even the one behind me that I was not very thrilled about, so that people would have the opportunity to see this. Our IT people beefed up our bandwidth. We even drilled a hole in the side of the building so that we could run the wires out to the van. The reason that I say this is I think there is some value in the community having the opportunity to actually watch this trial. I only have 40-some seats in the courtroom, so it's out there. So if people want to know what happened in the trial, they can go watch for themselves. They don't have to rely on what somebody posts about it or what somebody tweets about it. They can see the actual evidence that was presented. One of the reasons that I did this is so that the community, whether they agreed with the verdict or not, would have confidence in the way that decision was reached. So if somebody comes up to you and talks about how we have a baby killer that got off in Warren County, or we have an innocent person who was convicted and didn't do anything wrong, we can direct them to the actual evidence so that maybe you can get a better idea of whether or not they have an accurate opinion of whether justice was served in this case. So with regard to the matter of the sentencing, Mr. Knipp and Ms. Kraft, is there anything on behalf of the victim in the case?
Yes, Your Honor. The paternal grandmother, Tracy Johnson, would like to make a statement, and then the state also has a brief statement, Your Honor.
Okay. This is a bit of an unusual case because we actually have two individuals who have been designated as victim representatives because Ohio is now a Marsy's Law state. The victims have constitutional rights in the case. We have one person that was designated on behalf of the state, one person that was designated on behalf of the defense. So, Ms. Johnson, the floor is yours. If you want to come to the podium, you can, or if you want to stand there by the attorneys at counsel table, just as long as you're somewhere where the microphones can pick you up. Good morning, Ms. Johnson.
Good morning.
What do you want to tell me about this?
2 years, 4 months, 1 week. In case you were wondering, that's how old my granddaughter would be if she were here today. And as hard as I've tried to find the right word to describe, broken, shattered, destroyed, none of them seem to fit the amount of pain I have felt ever since we found out that not only did I lose my first grandchild, but my baby that I would lay down my life for without a thought lost his first child, and Skylar had no intention of ever letting us know. I found out from watching her interviews with detectives and her parents that not only did she know from the very beginning that Trey was the father, but also that she tried to secure her remains and planned on burying her without any of us ever knowing I've been told that the family is now trying to do it again as if we don't exist. But for a baby that she called it many times, we're just as much her family as Skylar is. She seemed perfectly okay with asking Tori, Trey's cousin, just a 3-month age difference, and more like a sister, to be a character witness for her, without giving her a few bits of crucial information, such as the baby being Tori's cousin. And yet she had no issue destroying and dividing an entire extended family. We at that point didn't think we could trust anyone if we couldn't trust the family that was the absolute closest person to Trey. It was almost a year before I sat down with Tori and found out that she had been lied to. I don't know if you know how we originally heard that Trey was the father. He had a DNA test on August 6, 2017. Then on January 29th, 2018, a Facebook page named him as the father because of a subpoena issue. My phone started blowing up while I was at work around 10 p.m. And then I headed to the prosecutor's office the next morning on January 30th, 2018. Got a phone call from Trey while I was on my way here. There was a news van outside of our house. He couldn't come in when he got home from class. So I turned around to go home and protect my baby, because I will always protect my baby first. Then he called back, told me they had left a card and a letter in the door. Once I knew he was safe, I had him send me a picture, and I went back to the prosecutor's office, and I waited until they finally told me it was going to be a while, and I should just go and someone would call me. I'd just gotten home when my phone rang, and that was the first time I ever spoke to Mr. Knippen. And he said, "Trey is the father. I'm sorry, we thought someone told you." 181 days. 5 months and 28 days. That's how long after the DNA test we sat wondering. But Skylar knew and didn't tell Trey. She's known from the very beginning it was his. She knew it was his baby. She said it in the first interview. And just went on like nothing had happened. In the time between taking the DNA test and where we are today, I've not only watched my son become a totally different person, and I will leave his medical diagnosis private because she's done enough to him, but I can personally tell you I've continuously been seen for depression, panic attacks, anxiety, and sleep issues. And my friends and family would tell you I've become withdrawn, cut off, and a shell of the outgoing person I've always been. It's hard to be around people when you're trying not to lose it in front of anyone and can't talk to people because you don't know who you can trust to keep your son's name away from the media and off social media. I've had multiple babies born into the family and with friends in the last 2 years. I've avoided gender reveal parties, going to see them at the hospital, first birthday parties. I found multiple excuses not to go over and see them when they were babies. When I was around them, I found myself making excuses, even more excuses not to hold them. I just couldn't bring myself to do it. Those that knew what was going on understood. Those that didn't really thought it was odd and knew something was wrong. I love kids, I always have. I'm that mom. My friends' kids all call and talk to me. I've helped raise many of them and consider all of them my own. I would have taken her in with Trey and raised her with no questions asked. You could have gone on to UC and never looked back if that's what she wanted. Her mom and Brandon never had to know. But now instead, every May 7th, I don't get to have a birthday party for my first grandchild. Instead, I get to send her balloons to heaven with notes telling her how much her daddy loves her, how much I love her, how much we all love her, and how much we all wanted her. For Christmas this year, I stayed home. I sent everyone else to do the normal Christmas traditions with our extended family, and then sent them to Southern Kentucky to visit all of my family, to do the same things that we always do. But this year I just couldn't do it. I couldn't stop thinking that this would be the first Christmas that she would love. She would have been into everything. Opening gifts all by herself, getting way too many toys than any child could ever play with. Then probably playing with a box. But this would have been that Christmas. Not her first Christmas, but the first Christmas she would have been big enough to enjoy. And then it crushed me. As we live with our grief and loss, she can now live knowing that her selfish decision was not her only choice. She had a way out.
Thank you, Ms. Johnson. Mr. Knippen, on behalf of the state.
Your Honor, the court is obviously very aware of the facts in this case, and it is clear from the defendant's actions that she never intended for anyone to even know that her daughter existed or that the skeletal remains would ever be discovered. But for her being confronted by her doctors at Hilltop, that child would still be buried in the backyard of their home without anyone knowing. And as a result of her conduct, the state would ask that you impose the 6 months of local jail time as part of the community control sanctions that the court is required to impose as a matter of law. Thank you.
Officer Binger, anything from probation?
Your Honor, the probation department is recommending some local jail time, compliance with mental health treatment, 100 hours of community service, corrective thinking class, and to maintain school or full-time employment.
Sure. Anything on behalf of the defense?
Yes, Your Honor. We would like for Mr. Richardson to address the court.
Do you want to up to the podium? Skylar?
Yeah, let's go up.
You can remain at council table, you can come to the podium, it doesn't matter to me.
But I want Mr. Richardson to be comfortable when he speaks.
Go ahead, Mr. Richardson.
Your Honor, this has been a difficult ordeal for the entire family, including the defendant's side or the prosecution side. My daughter is suffering from an eating disorder and we're concerned for her health. Anything you can do to help us get her home soon so we can take care of her, we greatly appreciate it. That's all I have.
Thank you.
Judge.
Mr. Rickers?
Thank you. Judge, as the court's well aware, Skylar's been under pretrial supervision for the last over 2 years. She was on house arrest for a year where she could not leave the confines of her home. Subsequently, I believe the court gave her a little more freedom with the curfew. It's my understanding she's been totally compliant with pretrial services. There's nothing to indicate whatsoever that she was breaking any of the rules or doing anything other than what the court expected of her. I think the court is well aware, at least I hope the court is well aware, that Skylar does have a severe eating disorder. She is down, I just learned, she's down to 89 pounds. 89 pounds. She's losing her hair. During the course of our representing Skylar, I had recommended to her and her mother that she needs to see her pediatrician just to make sure that her potassium levels, etc., were okay, because quite frankly, we were all afraid for her well-being. It turned out that Skylar and her mother went to the pediatrician, who immediately sent her to the emergency room, where she did receive treatment because of her low potassium levels, etc., which I believe results from this lack of eating nutrients. I would hope that the fact that she has lived this nightmare and lived under this cloud and lived under with the knowledge that she could go to prison for the rest of her life, and what kind of bearing that had on her, the court would take into consideration. Thank you.
Ms. Richardson, you get the last word in all of this. Is there anything that you want to tell me before I impose a sentence?
Thank you, Your Honor. I would do anything and above that you ask, and I understand. And I just wanted to say how sorry I was. I can sometimes be selfish, but I would like to think that I've become better in the knowledge that I've upset everyone and hurt so many people with what I've done. And I'm forever sorry, and I'm so sorry. I'm really, really sorry, and I understand. And thank you.
Ms. Richardson, we've been living with this case now for over 2 years. Actually, part of it is still in the Supreme Court, even as we speak right now. And I've always sort of thought of this case, Ms. Richardson, as a story of two little girls, Skylar Richardson and Annabelle Richardson. And, you know, I have a daughter about your age, Ms. Richardson, and I have a granddaughter about the age that Annabelle would be right now. The jury found that the state did not prove that you were guilty of killing your baby, either intentionally by way of aggravated murder or recklessly by the involuntary manslaughter. But in all of this mess that we have with this case, I think what often gets overlooked, Ms. Richardson, is just how precious life is. Your life, Annabelle's life, life is precious, and it should be protected, and it should be guarded in all respects. And I have reviewed all of the expert reports in this case. I listened to the expert's testimony. I firmly believe, Ms. Richardson, in fact, I know in my heart that if you would have made different decisions in this case, Annabelle would be here today. And I know that might be difficult for you to hear. Some people are inclined to think to themselves, you know, this is America. We kill unborn babies every day. But I don't look at it that way, Ms. Richardson. And the law does not allow me to consider the acts that you took prior to giving birth. But I think that your choices before birth, during birth, and after show a grotesque disregard for life. And I think when I look at this case, that to me is what offends the community sensibilities. But because of policy decisions that are beyond my purview, the jury was not permitted to consider those things, and neither am I. So I don't hold those things against you in the sentencing. I find that you are amenable to community control. It's a mandatory community control case. I'm going to place you on 3 years of basic supervision. I'm going to impose upon you the standard rules of community control, and I'm going to delegate to your officer the ability to make special or additional conditions as they see fit. I'm going to order as a term of your community control that you spend 7 days in the county jail. I'm going to credit you the 7 days that you have already done, which means that you are going to be going home today. Your stated prison term is going to be 12 months in prison. I'm not sending you to prison today, but if you violate the terms of community control, I can impose up to the maximum penalty in this case. This includes an optional period of post-release control. If I send you to prison, the adult parole authority then has the option but not the requirement to supervise you for up to 3 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically, whichever of those is the longer period, it's automatically consecutive to the sentence that you would receive for the new felony. None of this prison business matters to you at all as long as you don't violate the terms of community control. Officer Bittinger has made some excellent recommendations in this case about things that you should do. I'm not going to follow any of those recommendations because I think that it is sufficient for me to supervise you, and as long as you don't violate the terms of community control, our standard rules, hopefully we won't have any more issues. I'm not going to impose a fine in the case. I am going to impose the costs upon you. Is there anything else? You can be seated if you want.
Thank you.
on behalf of the state?
No, Your Honor. Your Honor, will the ankle monitor be removed?
Yes.
Thank
She
you.
shouldn't have it on now, right? I mean,
don't.
she came over from the jail.
I didn't know that. Thank you, Judge.
All right, we have one additional matter that I think needs some attention, is that the remains of Annabelle are in the custody of the Warren County Sheriff pursuant to the search warrants that were executed in this case. Mr. Knipp and Ms. Kraft, does the state have a position on this?
Your Honor, it's my understanding that both families are interested in the skeletal remains of the baby in this case, and I don't know how legally that is to be determined as to who should get the remains.
I mean, they were seized as evidence in this case pursuant to the search warrants issued in this case, right?
Yes, Your Honor.
I mean, there's nobody that knows more about it or is a better position to make that decision than me, right?
I don't know the legality of that, Your Honor. I don't.
Okay. All right. Does the defense have a position in this?
Your Honor, we have no objection to you making the decision on this. Mr. Richardson and the Richardson family had spoken with the Warren County Sheriff's Office between July 14th and July 20th. They had made plans now for more than 2 years to have a proper burial, proper memorial service. We've asked them, even without having Annabelle back, we've asked them to hold off on doing balloon releases and a lot of things that they've wanted to do because of the pending case. But the family has a burial plot, as I believe you saw, even though it wasn't admitted into evidence. And the Richardson family would like to bring closure for Annabelle and give her an eternal resting place. So we would request that you give the Richardson family Annabelle.
Mr. Richardson?
Yes, sir.
Do I have your word that those remains are going to be buried properly and that there is going to be access by the Johnson family so that they can pay their respects?
Absolutely, sir.
All right, I am going to order that the remains of Annabelle be released to the Richardson family within 7 days of the time of the sentencing entry, which will likely be today. Ms. Johnson, if the remains are not buried in a way that is appropriate and that you do not have access to pay your respects, please get in touch with my probation department or through the prosecutor's office and let me know that. I'm going to hold Mr. Richardson to the promise that he made here today, and if he does not keep that promise, he will answer to me in that regard. Mr. Richardson, once the arrangements have been made, please forward a copy or an email is fine, Mr. Rickers, as to what has happened, forwarded to the victim's advocate, the prosecutor's office, and probation. Is there anything else we need to do today?
No, Your Honor. No, Your Honor.
All right, finally, Ms. Richardson, you have the right to appeal this case to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you without charge. Good luck to you. We are in recess.
Thank you, Your Honor.
All right.
And there it is. That ends the entire case. Brooke Skylar Richardson would be sentenced to 3 years of probation on the charge of abuse of a corpse. To recap the entire case, the prosecution alleged that Richardson had burned her newborn child's body before burying it in the backyard of her home. The defense argued that Richardson was subjected to an overzealous interrogation because of the baby burning theory, which was at this point unsupported. A psychologist diagnosed her with dependent personality disorder and testified that the disorder could have led her to make a false confession. After the trial, a juror said that Richardson was not convicted on the more serious charges because, quote, the prosecutors did not prove their case. Following the trial, Richardson attended college and worked part-time at the law firm that represented her. Her probation was terminated in 2020, nearly 2 years early. In 2022, last year, she won a bid to have records of her conviction sealed. And that's going to do it for Ohio versus Richardson. I want to thank you all for joining me. I want to thank you all for your submission of this case for my very first throwback. If you have others, drop me a line in the comments. Drop me a line on the community tab. Email me, or even better. Let's go this route. If you have any ideas as to which throwback I want to do next, hit me up on Facebook. Hit me up on Twitter. Drop me a comment on YouTube here in the comment section or in the community tab. I'm on Instagram. You can follow me there as well. On TikTok. Or my best bet, you can email me. I would love to hear from you. The address is kingofhearts316_09@outlook.com. As always, ladies and gentlemen, this is the home for news without the drama, where your opinions matter, for lively debates, your voice is heard, and above all else, justice is served. Thank you all for joining me. Let's do this again. And like I said, give me an idea as to what case you would like to see me do next for another BETHEA'S BYTE throwback. Until then, I'm Ernest Bethea, the last outlaw. I love you guys. Take that love, spread it around. Be good to yourself, be good to others. Be good to your mental health. And I will see you again next time. Until then, you all know what to do. Bite this. Hey guys, this is the Last Outlaw saying thank you to all of you who watched this video and subscribed to BETHEA'S BYTE Reloaded, your drama-free true crime destination. I couldn't dream of doing this without you, so thank you. Did you enjoy this presentation? Are you looking to get more information on everything presented here? Are you looking to give more feedback on this presentation? Here's what you can do. Like this video. The more eyes on this video, the more this information is spread to others, which brings us a step closer to justice served. Share this video to your social media. Just like dropping a like, the more eyes on this video, the closer we get to justice served. Drop me a comment, whether it's on the topic or the presentation. I am open to all comments, whether it's a theory, a speculation, or a suggestion. I will respond to all. If you haven't subscribed yet, what are you waiting for? Hit the subscribe button to show your support of this little true crime engine, powered by you. Set the notification bell to all for future videos. Be sure to follow BETHEA'S BYTE Reloaded all over social media. At BETHEA'S BYTE Reloaded True Crime on Facebook. At EKB316 on X, formerly known as Twitter. At BETHEA'S BYTE Reloaded on YouTube. At EKB316 on Instagram. At King of Hearts 316 2021 on TikTok. You can drop me an email as well. The address is kingofhearts316_09@outlook.com. This is your home for news without the drama, where your opinions matter, for lively debates, where your voice is heard, and above all else, justice served. This is BETHEA'S BYTE, and it's reloaded.